SJC-12873, Daniel Wright v. Central Mutual Insurance Company.
All right, Mr. Lamont,
Your Honor, may I interrupt one moment?
Yes, Mr. Mason. Yes.
I want one point of clarification. May we refer to this as Section 7B of Chapter 369, since we do have Chapter 55, just for purposes of making it easier?
Why don't you address that in your argument? I'm not sure if I quite get your point right now. So, I'm not quite sure how to answer that. So why don't we can address that during the course of your argument. So
okay.
first we'll hear from Ms. Lamondia-Wrinkle.
Great. Thank you. Good morning, Chief Justice and Associate Justices. Thank you for giving me the opportunity this morning to bring before you the case of Daniel Wright. I am Catherine Lamondia-Wrinkle, and I have represented Daniel Wright since 2014. Mr. Wright suffered a right knee injury at work that was complicated by the development of a deep vein thrombosis and complex regional pain syndrome, a debilitating pain condition. He suffered through a range of treatment options, all to no avail, before discovering medical marijuana. He described his life before that time as filled with pain. Since then, he has reduced his use and dependence on medication. He wants you to know that currently he is a different person because of the benefits of medical marijuana. He is looking at returning to college and returning to work, something he thought unthinkable a few years ago. We contend the Department of Industrial Accidents erred in finding the Controlled Substance Act preempted it from requiring Central Mutual Insurance Company from paying for and or reimbursing Mr. Wright for the cost of medical marijuana to treat his work-related injury. The insurer has not contested, and the Department of Industrial Accidents so found that the use of medical marijuana in the case of Mr. Wright is a reasonable and necessary treatment for his condition. His diagnosis of chronic regional pain syndrome is the exact type of condition the Massachusetts medical marijuana law was intended to provide for. The purpose of that law melds well with the purpose of the Workers' Compensation Act, both of which are beneficent acts. There are several points we wish to make. First, Central Mutual is not a health insurer. Most significantly, workers in the context of workers' compensation claims give up their right to sue their employers in the event of negligence in exchange for those benefits. Second, as to preemption, it exists when there's no direct conflict in the law, such as when it is impossible to comply with both federal and state law. While the CSA, which was passed in 1970, made marijuana a Class 1 substance, the policy memos recently show a lack of federal interest in prosecuting marijuana claims unless they are directly related to drug distribution and trafficking or manufacturing. Moreover, Congress, in passing its congressional budgets, have handicapped the Justice Department from pursuing states that have passed medical marijuana laws. This court noted in Barbudo versus Advantage Sales and Marketing that since the enactment of the CSA, 90% of the states have enacted laws regarding medical marijuana, and that reflects their determination that when lawfully prescribed, it has a current accepted medical use and treatment. Further, as to preemption, the federal government has deferred to states in terms of the practice of medicine within their own boundaries. Quoting the Supreme Court from Gonzales versus Oregon, the CSA makes no intent to regulate the practice of medicine, which is understandable given the structure and limitations of federalism, which allows the states great latitude under their police powers to legislate as to the protection of the life, limbs, health, comfort, and quiet of all persons. Massachusetts has a compelling interest here, particularly in providing medical treatment to its injured workers. In the most recent decision from New Jersey, Hager versus M&A Construction, the Superior Court of New Jersey Appellate Division found that the employer's act of reimbursing an employee for the purchase of medical marijuana did not violate the CSA. As there was no conflict, the employer was not required to possess, manufacture, or distribute marijuana, nor would the employer have the requisite intent and active participation needed for an aiding and abetting charge. Lastly, as to the amicus brief filed by American Property Casualty Insurance, the focus on that brief seems to be workplace safety and the efficiency of medical marijuana. This is not a workplace safety case, but rather the issue is providing significant relief for those who are injured, such as Mr. Wright with the debilitating pain condition. It's also not a challenge to the efficiency of marijuana, as the medical marijuana law is already in place, and we hope through our case to extend that benefit to a certain class of individuals, such as Mr. Wright. In conclusion, we believe that Massachusetts should protect Daniel Wright as an injured worker. He should not have to pay $25,000 out of pocket to advance his own recovery to the point where he will be able to return to work. We're asking you to afford him the protection of the Workers' Compensation Act and the medical marijuana law. Thank you.
Okay, Justice Lang.
Yes, good morning. I'd like to focus on the statute rather than on the federal issue. I'd like to focus on a Massachusetts statute regarding marijuana, and in particular Section 7, limitations on the law.
Okay.
I take it now, Section B, can you hear me?
Yes, I can.
Okay. Section B says that nothing in this law requires any health insurance provider or any government agency or authority to reimburse any person for the expenses of the medical use of marijuana. So how can you say our statute somehow is consistent with the idea of paying, reimbursing?
Well, I think, first of all, it says it doesn't require, but it doesn't prohibit the Department of Industrial Accidents from awarding that benefit to injured employees. So I think it says it doesn't require, but I certainly would argue that it's well within the construct of the rules and regulations of the Department of Industrial Accidents and its law to order that as a benefit to injured workers. And then the second part of that is that Central Mutual is not a health insurance carrier, and I would argue...
But it's a government agency or an authority, right? It's a government agency or authority.
The government agency is, the authority is the Department of Industrial Accidents, absolutely. It doesn't require them to do that, but again, they're not relying on that as being the reason why they're not awarding it in this particular case. I certainly would argue that it doesn't preclude them from providing that benefit.
Okay. Let's go to F. Nothing in this law requires the violation of federal law or purports to give immunity under federal law. What is your position on whether this insurance, the person who would be paying, the company that would be paying the benefits, would be at risk of being considered to be in violation of federal law?
I look at the New Jersey case that was just came down, where they talk about the fact that the insurance company would be manufacturing, wouldn't be distributing, and wouldn't be in any way committing any one of those acts. They're not in possession of the marijuana. They also said they were arguing that they wouldn't have the requisite intent and the active participation necessary to be charged with aiding and abetting, so that I guess our position would be that they wouldn't run afoul of the CSA.
Okay. Now, that New Jersey case, is that cited in your brief?
It was not. It came down after my brief.
Can we have the citation to it, please?
You certainly can. It is right here. If you would hold on for a minute, I would be happy to.
Or you can do it in a 16-L letter if you want to take your time to do it now. I don't care. Chief, is that all right? Chief?
Yes. Why don't you do it in a 16-L letter? That's the more appropriate form.
Yeah.
Okay. I do have it in front of me, but I will do it that way, yes.
All right. I'm done with questions. Thank you.
Thank you.
Justice Graziano.
Yes, good morning. Just one question. With respect to the CSA is obviously the statute or one statute that applies, and then we have various administrations have federal guidance as to whether or not they're going to, how closely they're going to enforce marijuana laws in states that allow either medical or recreational marijuana. But those can be fleeting, right? Because administrations change and policies and DOJ policy changes, but the CSA, like it or not, endures. How do you respond to that?
Yeah, I get that they can be fleeting, but when you look at the history, the Act goes back to 1970. We're now in 2020. I think things have been fairly consistent with respect to policy for the last, at least 10 years, and we still see Congress supporting prohibiting the Justice Department from using the funds to go after states, and frankly, they haven't at this point. We all hope to see legislation come down in the very near future that just removes this as a Class 1 substance altogether. But I think when you look at the tide, no matter what administration, you're going to see the changes coming where there's going to be direct legislation removing it from Schedule 1.
Right, but whether it's solitary or not, and whether that's good policy or not is obviously a different issue. But how do we tell a business entity go ahead and violate the law because you probably won't get prosecuted?
I think that goes back to the question that I was asking or answering previously, where are they really violating the law by complying with an order? No, because they're not aiding and abetting, and they're not manufacturing, distributing, or possessing. So if you approach it from that perspective, regardless of what the CSA says, they're not violating the law.
And where does the law help us or hurt with regard to banking and how that controversy has played out with federally in states that allow recreational medical marijuana?
I think the easier approach would be to require reimbursement so that they're not directly paying for it. I think that would be the safer.
Actually, I think I asked a bad question. I should rephrase it. I stated you wrong. I meant as far as banks that don't want to finance, that were scared off of taking marijuana money, and there was a big controversy over whether or not financial institutions would get involved in the marijuana business, if you remember that. How has that played out, if you know?
I don't know how that's played out lately. I mean, I guess my gut reaction to whether that should be an issue goes to no, it shouldn't be an issue because, again, those are checks, that's cash, they're not involved in, again, the distribution, the manufacturing, and the items that have been set forth as really being the focus of the CSA. So I don't think banks should be concerned any more than Central Mutual Insurance Company should be concerned with violating the CSA. But again, I'm not up on where, in terms of that sort of.
And that was my question, because I was wondering if we could use that as an analogy to help us resolve this case.
I think that they stand in the same place as Central Mutual Insurance, that I think that they're just taking checks and operating a business. They're not actually engaged in anything with respect to aiding and abetting or supplying the marijuana. And again, this is all being done under the legitimacy of an order from the Department of Industrial Accidents.
Yeah, thank you.
Justice Louie.
Yes, good morning. You referenced the Baruto case.
Yes.
In that case, as you know, in Chief Justice Gantz's decision, there's a claim of handicap discrimination in the workplace and an accommodation for medical marijuana, and it seemed an important part of that decision that the employer's policy toward drugs in the workplace wasn't being exposed. They weren't exposing what might be use of marijuana in the workplace or potential prosecution, no matter how theoretical it might be. And they weren't sort of tying their company, their brand, to the use of marijuana. Doesn't that suggest here that you have an issue separate and distinct from Section 7, separate and distinct from the regulation, and separate and distinct from preemption as far as requiring reimbursement?
Well, the amicus brief that was filed focuses on the workplace issues, and those are a whole different set of issues that come to pass with the use of medical marijuana. But I don't think that those are relevant to the case that's before us, because the issue really, in my case, is providing medical marijuana as a treatment option for somebody who is totally and permanently disabled and suffering from a significant pain condition that prevents him from going back to work. it's a treatment option that he should be afforded just like everyone else who has a significant pain condition. So this case is so pointed at that one particular issue that I don't feel that it is a workplace issue, and that's why I feel like the amicus brief sort of missed the point on what this case was about versus what they were writing about.
Thank you very much. That's all I have.
Justice Budd.
I don't have any questions. Thank you.
Thank you.
Pfeiffer.
Now
Thank you.
exiting.
Leonard Nason.
Good morning. Good morning. I have a couple questions. One is related
Sorry,
to
Justice Pfeiffer. I'm
yes,
sorry, we appear
yes.
to have lost Mr. Nason. Is his colleague on the call?
Yes, I am.
And your name, sir?
James Ramsey.
Okay. And did he leave because of any particular reason, or do we just need to get him back?
I think we just need to get him back. I suspect he lost his cell phone reception.
Okay. Why don't we wait a moment and
okay.
I will send him a text.
You can text him and tell him we've lost him.
He's dialing back in now. He's in.
Mr. Nason, are you in? I've not heard anybody entering the call.
Okay. I suspect they accepted his code. Stating his name now.
Mr. Mason, do we have you? I don't hear anybody entering the call.
Trying to clarify, Judge. I apologize.
Now joining
Leonard Nace.
Okay. Sorry, Justice Seifer.
Oh, sure. Thank you. Welcome back. My question relates to other penalties that a state could,
now exiting
Leonard Nace.
Uh-oh.
Does he have a landline?
He does not.
And he's calling from Lexington?
Yeah, he has more than one cell phone, though. I've asked him to use the other cell phone if this happened.
It's a telephone call. Shouldn't.
Yeah. Right, but, well, I mean, in his defense, Chief, I don't have a landline either.
Right, I understand. No, I understand. But generally, we're not talking about.
Oh, I see. You're not far away.
More sophisticated than a telephone call.
Right, right. Well, I had this problem yesterday.
I know, but you were back in about a minute. So. Mr. Ramsey, does he realize he's off again?
Yes, I just sent the text telling him that he's off again. He just replied. It was not his phone. It just simply ended the call. So I asked him to use the other cell phone.
now joining
Leonard Nace.
Okay, now Justice Seifer, go ahead.
Okay, thank you. I understand there's some concern about the individuals being prosecuted or the agency or something if they violated federal law or were perceived to. But beyond that, there are other penalties that should the federal government decide that Massachusetts is not conforming with the federal law that they could impose on the state. Has any contemplation been given to that, or has anybody discussed that in any of the cases you've read? I mean, they could withhold funding for things. There are all sorts of other kinds of grants could be withheld if we're not in compliance. So my concern is something a little bit broader than the individuals involved or the agency involved.
Yeah, the only thing that I've read on that says that the federal government has taken no action against any of the states that have enacted medical marijuana laws and any of the states that have permitted or required workers' compensation carriers to reimburse employees for medical marijuana. So the suggestion is that they're not going to enforce it, and that's consistent with the policy memos and everything else that's come out at this point. That it appears that everyone's accepting it as a legitimate medical treatment when it's prescribed by a doctor. So I haven't found anything with respect to the federal government taking any negative action towards the states that are. But
it has been contemplated and discussed and thought about by other people. Is that right?
It seems that way, yes.
Okay. My other question is, why is this not something that the legislature should just address and say that it's okay? Why is it us?
Well, I think the legislature has already addressed the use of medical marijuana, so that has been determined that it's to be or can be prescribed for legitimate medical purposes. The Workers' Compensation Act awards benefits to injured workers, medical benefits for all sorts of conditions.
Along those lines then, if I can interrupt for a moment, what about insurance carriers where sometimes there's a prescribed medication that an insurance company does not want to cover directly, but you can apply for reimbursement for that? Would this also be in that kind of category, that if a patient was prescribed medical marijuana, they could apply to their insurance carrier for reimbursement outside of workers' compensation?
Generally not. I mean, Because what happens in the context of a workers' compensation claim, a health insurer won't step up and pay for anything.
Right. No, I understand that. I'm not talking about, I'm saying let's move out of the workers' comp world and into everybody else's life who's non-workers' comp and say they're prescribed it for pain and they want to get reimbursed from their insurance company. Why shouldn't they in in similar circumstances? Wouldn't there be a fair argument that we should do that also?
Well, that may be an argument, but right now you've got that language that said that the health insurers aren't required to reimburse. However, that doesn't mean a health insurer cannot reimburse. The health insurers could certainly take on that risk if it so chose to, but right now they're not required to. Our case is a little bit different because I think whether you call it a loophole or whatever you call it, the Department of Industrial Accidents can award that benefit, and in this particular case, they found it was reasonable and necessary treatment. The only reason why they said we're not going to do it is because of preemption and what we feel that the CSA prohibits us from doing. So, workers' comp is just different, and I try to make the point.
Well, I understand that. I know it's different. I'm just thinking more about the next case or parity with other kinds of medical benefits. And again, going back to why is this a case for us and not the legislature? Have there been any other cases, and I admit I'm not as deeply involved in the workers' comp world as some of my colleagues, where we have added a benefit?
There have been other cases where the Workers' Compensation Act has been interpreted to require the payment of medical marijuana. In those cases, other states, New Mexico, New Hampshire.
But I meant in here. No. I mean in Massachusetts, not marijuana, but something else that wasn't contemplated, like some new kind of physical therapy, or have we ever defined the benefit, the specific kind of reimbursement? Added a category.
Yeah, I don't see the court having done that, but I see the department itself as having done that, has accepted acupuncture, has accepted.
Okay, and was that that wasn't challenged though, right?
No, it wasn't challenged, because those were probably a little bit easier to make the determination, but they have interpreted at that level, they have interpreted other types of treatment as being acceptable.
Okay. All right, I'm content. Thank you.
Thank you.
Justice Kafker.
I don't understand your argument about health insurers. So the workers' comp system is a gigantic health insurance for workers. It provides, hundreds of millions of dollars in health insurance benefits, doesn't it?
To some extent, that's true, but it's also a different system that's bargained for in a different way. It covers everybody, no matter how they're hurt at work, whether they bend over to tie their shoe or whether they fall. But to get that benefit, workers give up their right to sue their employers for negligence. So there's a big bargain.
But that's a health insurance. You're not supposed to have to sue to get your health insurance either. If you have health insurance, you're supposed to get health insurance. So I don't understand why the suing would have anything to do with that.
I think because you give up a right, you give up a substantial right in exchange for workers' compensation benefits, and you also are limited as to what you can get. You're paid a disability wage. You're not paid a disability wage through a traditional health insurance. So an employee, if they're out of work, they get paid something. Medical treatment is set by a rate-setting commission. Sometimes the rates are awfully low, but that's another story in and of itself. And you have an immediate way to address any type of problem.
By the way, this is a provision that's in 20 states, right? This is all over. This was some kind of national model, this exclusion of health insurance. And the language in some of the other states expressly references workers' comp insurance. Arizona, other states, right? So I'm perplexed. And then you suggested that the health insurer might be at risk of being prosecuted, but the workers' comp insurer wouldn't they be in the same position? Wouldn't they be in the same position as the banks and everyone else?
I wasn't sure that that's what I said. I probably was pointing to the fact that the statute specifically addresses health insurance in terms of stating nothing in the law requires a health insurance provider, but I don't think a health insurance provider would be any more at risk than a workers' compensation insurer under the CSA.
But again, I don't get why. What? I mean, it makes sense to me that we would exclude that. I mean, the legislation excludes sort of people who don't want to be involved in the marijuana world. It protects those who want to buy it, those who want to sell it, but it seems to carve out, health insurers or others who would be sort of involuntarily drawn into the marijuana world. Don't we want to respect that distinction?
Yeah, well, I guess who are we trying to protect in all of this? And my position is that our job really is to protect the people who need it the most. And when we're using medical,
to enforce the law, isn't it? I mean, if it's one thing to expose someone to federal, oversight who wants to take this on, who wants to buy the marijuana or sell the marijuana, isn't it another thing to bring in? Interstate business. I mean, this is an interstate company, right? This insurance company?
Sure.
Where is it headquartered?
I think out in Wisconsin, but I'd have to let Attorney Nathan address that.
Is medical marijuana legal even there? Is it?
I don't know the answer to that. I don't think so at this point.
And then the last question, you're talking about your person not coming back to work. But the whole point of workers' comp is to bring you back to work. So
True.
Isn't the next case going to be someone who needs medical marijuana to go back to work? And then doesn't that just run right into Barbudo and our concerns about marijuana in the workplace? Because he's permanently and totally disabled. Is that right? Is he a permanent and total disability case?
Sure, yes.
He's not a temporary total. He's a permanent and total?
Yeah.
So, but the next case, when we have someone who needs this to get back to work, he's injured his knee and why are you going to be suggesting that he would not be entitled to the marijuana, but your guy would be?
Well, I'm just saying there's a distinction right now in the case before you. And the case before you is if this offers Mr. Wright some relief and benefit, I guess a lot of relief and benefit as the department found, why shouldn't he be entitled to that benefit? We've sort of let the cat out of the bag. If we have medical marijuana legislation where we're saying it can be used for legitimate medical purposes, and Mr. Wright's case is a legitimate medical purpose, then why can't he get that through the workers' compensation system? Doesn't that system owe him that? He was injured at work. He's done everything he's supposed to do. And so I'm looking at it as a defined issue right now, meaning let's... But again,
I take it your argument would be that even if he were coming back to work, if marijuana is the best treatment for him, he should be entitled to keep getting the marijuana and working.
And that may well be the case. And again, I understand that was the issue that came up in the Barbudo case. But the question also then becomes, it's a much more subtler discussion in the case of workplace and marijuana use. And again, I don't see a real distinction between allowing someone to come back to work on medical marijuana and allowing someone to come back to work on narcotics. There's certain machinery you can't operate, you can't drive. And so in those particular cases, you're going to have that dialogue about what's appropriate in a given case, given anybody's medication, what they're taking, and what the side effects are going to be. And medical marijuana shouldn't necessarily be any different than a discussion about OxyContin use on the job or oxycodone use on the job.
And the last question is, so our U.S. attorney here has said that he's, prepared to prosecute marijuana offenses, right? Welling has made public statements to that effect. Don't we have to recognize that? I it's not, I mean, there's, whether he decides to pick on one of these people or not, as opposed to someone in the banking field or something else, that it's just not as secure, at least here, given that statement, is it?
Well, I think you also have to look at going back to, like we talked about the New Jersey case, is it aiding and abetting? Is it procuring? Is it distribution?
The New Jersey case is just a superior court decision. It's not even an appellate. It's not the New Jersey Supreme Court, right?
It is, though. It's the Superior Court of New Jersey Appellate Division.
Right, but it's not the top court. You know,
right.
Yeah. Okay, that's all I have.
All right.
This is Chief Justice Gantz. Let's turn to Chapter 152, Section 30, which is, after all, the workers' comp provision.
Yes.
So I know that there are certain expenses which either no health insurer or most health insurers do not cover, and I'll use acupuncture as an example. Under Section 30, if an employee uses acupuncture, is there an obligation of the insurer to pay that if it's viewed to be a reasonable and necessary service?
That's currently being covered, yes.
Okay, so if he had acupuncture and that was viewed an adequate, I guess the language is whether it's an adequate and reasonable health care service, correct?
Yes.
So even though he could not go to his health insurer and say, pay for my acupuncture, the workers' comp insurer would be obligated to pay for acupuncture.
Yes.
Chiropractic?
Yes.
And trying to think of what other...
Massage therapy.
Massage therapy would also be included.
Yes.
So, now the last sentence of Section 30 says, where services, which I assume means adequate and reasonable health care services, are provided to employees under this section, the reasonable and necessary cost of such services shall be paid by the insurer. So, going back to the acupuncture and massage therapy examples, if that is viewed to be an adequate and reasonable health care expenses, the insurer is required by state statute to pay it?
Yes.
Even though the health insurer would have no such obligation?
Correct.
All right. And here, is there any dispute, or is there, trying to go back to the findings made, was there a finding that the medical marijuana here was an adequate and reasonable health care service?
Yes, there was.
So under Section 30, there is an obligation to pay that.
Correct, yes.
So the question is whether or not it would be a crime to do that. Whether or not the insurer would be committing a crime to do it. So, and I guess I'll ask Mr. Nason about that. But the theory, I guess, would be that you'd have to say that it's be conspiracy or aiding and abetting when a health insurer who is required by state statute and arguably required pursuant to an order of the state Supreme Court to pay something, they would arguably be found to be conspiring or aiding and abetting with the worker to use marijuana. Would that have to be the theory of the crime?
That's what I've read.
Is there any case anywhere where any prosecutor federally has made such an argument that where a state Supreme Court interprets a state statute that there's an obligation for reimbursement, that the compliance with that statute and with that court order or court direction would be viewed to have the knowledge element involved in conspiring or aiding and abetting?
I haven't found anything on the criminal level, no.
Well, if it's not a crime, it's not. The only claim here is that preemption because of it being a crime, correct?
Correct, yes.
I have no further questions. Does any other justice have any questions?
Yeah, I have a follow-up. Justice Kapp again. How is if it's illegal under federal law how is it reasonable and necessary, particularly when there are other drugs that could serve him. He may not like them as much, but how is it how is it reasonable? Anyone said that it's reasonable if it's illegal?
The Department of Industrial Accidents found that it was reasonable and adequate because to understand it, I think he received a significant amount of relief. It decreased his reliance on narcotic medication and other medication that had terrible side effects. There's such a move at the department these days to move away from all the narcotic medication, and they have all these programs designed to reduce narcotics. And if medical marijuana is one of the ways to move away from some of the heavier and more negative drugs, then that's certainly a reasonable form of treatment. And if it's successful in reducing pain, then it's certainly an adequate treatment.
Did they actually use those terms that it fits that definition, or is it just saying they use that in their analysis?
Yes.
Okay, and again, and the health insurance, the idea that this would not be payable for health insurance. I mean, acupuncture is completely legal everywhere. Health insurance, we found any cases in which health insurance picks up this type of stuff, this dichotomy between the workers' comp system and the health insurance system. Are there any cases out there that talk about that it would be impermissible to do this under the health insurance, but it's required under the workers' comp? Any guidance on that?
I'm not even saying it's not impermissible to do it under health insurance. It just said it doesn't require them to do it. If Blue Cross and Blue Shield wants to expand it to its list, I think it certainly can. But the law just says it's not required to.
Maybe I misinterpreted your back and forth with the chief. My understanding was the chief said, use the example of acupuncture. It's not, they don't have to pay for it under their health insurance, but they would be required to do so under workers' comp. That's news to me. I'd like to, is there any examples of that anywhere that I can look up?
I just know, certain health carriers don't offer acupuncture as a covered service, even though it's a legal service. I mean, some health carriers.
But then it's required. Then the workers' comp decisions that say that then it's required to be paid by the workers' comp insurer.
Right, if it offers a benefit and it has a purpose. So there's an analysis to any type of treatment, even if it's a surgical procedure. Is this employee going to benefit by the procedure? And if so, then it's reasonable and adequate care. We deal with a lot of issues over whether even a given surgery would be beneficial to an employee if it's only 50-50 chance of success. And so all types of treatment has that analysis before the board as to whether there's going to be a benefit.
But again, and there's case law, either workers' comp case law or the Mason treatise. We're going to be able to find that in somewhere?
I would believe so, yes.
Okay, thank you.
Thank you.
Any further questions of the justices? Okay, well, speaking of the Nason treatise, Mr. Nason, you're up.
Should I start with my summary?
You may.
Okay. Well, as you know, the Section 7 has limitations, and the limitations are, one, that no health insurer shall be required as Central is a health insurer, I submit. And I think it's pretty clear that Central is a health insurer providing health insurance benefits and wage replacement benefits. It's pretty clear under Sections 13 and 30 that they are required to pay reasonable and necessary health insurance benefits, including acupuncture and massage therapy. And yes, you will find case law in my treatise that has been taken over by reviewing board judge Thank you. Thank you very much, Dr. Koziel. further, that no government agency or authority, such as the Department of Industrial Action, shall be required to reimburse any person for the expense of medical marijuana. And it's also clear that under the CSA, Controlled Substances Act, the federal law, that the manufacture, distribution, possession, payment, use, or of marijuana is a crime. There's no exception to that. And under the Supremacy Clause of the United States Constitution, the laws of the United States shall preempt state law when a positive conflict presents itself, as it does in this case. And notwithstanding the shifting policy positions of the various presidents and the attorney generals that have served under them, the law has not changed. And the use, sale, and possession of marijuana is still a crime. And Massachusetts recognizes this, and they say so in their limitations. It's expressly stated that you will not be indemnified or protected against federal law in Section 7's limitations. Further, they have said, and the case law has said it, and you have all been talking about it for the last 45 minutes, that Central Mutual does not want to risk being charged as an aider and abettor to the commission of a federal crime. You've also been discussing, and I think it's pretty clear that you all recognize, and I believe that while you've been discussing just regular accident health insurance, that they don't want to risk being charged as aiders and abettors, which is why they're not voluntarily stepping to the plate and offering medical marijuana as one of their services, despite the fact that many of them don't even offer massage therapy or acupuncture as one of their services covered under their policies. Further, there is no objective scientific evidence that medical marijuana has any accepted medical use, nor is there any FDA approval. Further, right off the bat in the limitations section, Massachusetts recognizes that marijuana can impair one's ability to drive boats, drive cars, operate machinery, etc. It does impair one's ability. Further, the Department of Industrial Accidents has no enforcement power. So if an order were to have issued, hypothetically, in favor of Mr. Wright, or if this court were to find that Mr. Wright is entitled to be reimbursed medical marijuana by my client, Central Mutual, or if then my client would not voluntarily pay it, the employee would have to take that order and go to the Superior Court to have it enforced, to have Central Mutual pay it. The likelihood that Central Mutual will pay it is slim and none, because they would not want to risk paying it and then be exposed to criminal prosecution. And likewise, Central Mutual would probably turn around and request reimbursement under Section 37, the Second Injury Fund Act, where they have an agreement with the trust fund to be reimbursed up to 75% of any benefits they are required to pay on behalf of Mr. Wright, and would request reimbursement from the trust fund for benefits, including medical marijuana, should they ultimately have to pay it, which the trust fund, I am sure, would refuse to pay it. They would also seek an enforcement order from the Superior Court. And guess what? The Superior Court would then be in the position of violating both the state law and the federal law. Query, what do we do then? The Superior Court would be violating the state law, which says no authority or agency shall be required to reimburse for medical marijuana, nor shall an insurer, a health insurer, be required to reimburse for medical marijuana. And that would create one heck of a quandary for the Superior Court, for the state agency, and for the insurer, who would be facing a criminal act. Finally, the American Property Property Casualty Insurance Association filed an amicus brief. They've made many of the same arguments that Central Mutual has made in this case. However, there is one disturbing comment they made on page 4 of their brief, and that is they said that if Mr. Wright, if an order, or if this court were to find that Mr. Wright were entitled to reimbursement of medical marijuana under the Workers' Compensation Act, it could potentially destabilize the Massachusetts workers' compensation market. I can't specifically myself say what that means. However, if it means that workers' compensation insurers, self-insurers, would leave the state or because they don't want to be exposed to violating the CSA and be exposed to federal prosecution, that would be a tremendous disservice to the employers and employees of the Commonwealth of Massachusetts. And what I would say in closing is when and or if Congress changes the law, we are all, and when I say we, I mean the courts, are bound by the rule of law, and we must follow the rule of law until the U.S. Congress decides to change that law. We are a nation that should be following the rule of law, and the federal rule of law is that rule of law, despite whatever our personal preferences are. And until it changes, we have no choice but to follow that rule of law. Thank you.
All right.
And I'll entertain any questions. And in fact, if you want, I anticipated some of the questions with regards to
I think Mr. Nason, I think you've used up your time. It's time for us to ask questions. You may anticipate them, but you're going to have to wait to hear from them. So, Justice Lankford, you may proceed.
I wondered, Mr. Nason, whether you were familiar with a case from New Jersey that we have not had a chance to read and apparently has just come out.
I'm vaguely familiar with it. I know that it's not the highest court in that state to rule on it, and I'm not intimately familiar with it. I must confess.
Okay, all right, that's good. Well, the questions that I would ask are the ones I think that Chief Justice Gans is going to pursue, so I'm going to let him do that later, and I'm not going to take up any time. Justice Gaziano may certainly ask any questions he wants as the Chief commits it.
Justice Gaziano.
Thank you. I have no questions, Mr. Nathan. Thank you.
Justice Louis.
Sure, thank you. This New Jersey Appellate Division of the Superior Court determined that a hypothetical conflict of possible punishment because there is, in fact, preemption doesn't constitute a reason to not reimburse medical marijuana. So basically, as I understand it, New Jersey Superior Court is saying is that a conflict doesn't suffice to satisfy potential conflict doesn't suffice to satisfy preemption. What do you say about the issue of the unlikelihood of a prosecution? Is the unlikelihood of a prosecution enough to say that there's not preemption, or even that it's really, really unlikely?
No, I don't think so, because then you're talking about the shifting the winds of policy that is made by either the president, the shifting winds of the attorney general. It doesn't change the fact that the law is still on the books. That is, the federal law is still on the books, and it is still the law of the land, and it's still the supreme law of the land. And if there's a positive conflict between the state law and the federal law, the federal law is going to win out every single time. In fact,
go ahead, I'm sorry.
By analogy, I might bring up Judge Joseph's situation when she was indicted under the ICE statute, where she, actually she took positive steps to aid abet an undocumented worker. But she was the first judge since 1786, I believe, to have been indicted by an attorney general in any state in the Commonwealth of Massachusetts And that was a policy decision made by President Trump down to our Attorney General here, or in Massachusetts, to indict her as a message, sending a message to our state that we can arrest judges for aiding and abetting and violating our crime. It had never occurred in hundreds of years that any judge was indicted. It's hypothetical, but it is a mirror image of what can happen. In our case, it can happen to an insurance company. And
let me ask you this, because the chief was asking a couple of questions about this. Would assume that we're dealing with your client being a health insurance provider for the purpose of my question, and not in terms of asking questions about the regulations or Section 7B, but are they really an active participant in the commission of a crime if they're following a state court order? Would there be some even analogy to duress or necessity defense? They'd be in a tough position. They'd be caught between basically violating it or refusing to abide by a court order, and probably their poor attorney would be held in contempt for violating that order. And of course, their fines monetarily would significantly mount, and there would be nothing to prevent Attorney Lelling to charge Central with aiding and abetting and providing money to interstate commerce, because they have to transfer that money through the banking system to pay and cut a check to Mr. Wright to reimburse him for his medical marijuana. And that would involve the federal system, and that would involve interstate commerce and the Commerce Clause, which would be a violation of interstate commerce. It would certainly, and it would also bring into effect Central's, Central Mutual's licensing provisions to write in all the states that they write workers' compensation and other lines of insurance. All right. Thank you. I think you answered my question. I have nothing else, Chief.
Justice Budd.
I have no questions. Thank you.
Justice Seifer.
I have no questions. Thank you.
Justice Kafka.
I'm confused because you seem to, if we take your argument to its logical extent, I take it you're saying the whole system's illegal, right? Not just requiring your client to do it. You're basically saying all of our medical marijuana laws and our ballot initiative, it's all illegal and unenforceable, right? Is that what you're saying?
As requiring an insurer, yes, I am saying that. As requiring any party that does not want to participate in the state laws program, yes, I am saying that. I believe.
So, are you saying then that what saves this is the fact that third parties are not being required to participate in this? Is that? I'm just not sure I understand how that works in terms of preemption analysis.
Well, for example, our state law, and I think most of the state laws would say, a physician may, if he or she wants to be a registered physician to prescribe medical marijuana, can do so and be protected under the state law. But they cannot be forced to participate in the program because it is a federal crime. So you cannot force them to participate. Just like you cannot force anybody to participate. However, if an individual wants to voluntarily take the risk, if you will, to buy marijuana, use marijuana, be a doctor, and prescribe marijuana, you can do so, and you will not be prosecuted under state law That does not mean you're immune from prosecution under federal law. And I think that's true in every single state that has legalized medical or recreational marijuana.
You briefly in your introductory statement addressed the questioning the Chief was asking. Can you slow down and explain to me what you were saying there in the beginning about acupuncture and this and that? I'm trying to understand that argument that there are certain things that workers' comp insurers have to pay that health insurers do not have to pay. I thought you addressed that, but I couldn't follow what you were saying.
I'm sorry. I apologize.
Maybe me,
If an employee and his or her physician can justify to a judge, an administrative judge, that is the judge at the trial level, that a particular procedure, such as massage therapy or acupuncture or chiropractic treatment, is a reasonable and necessary medical treatment that will help the employee with their pain, with the improvement of their medical condition, that will help restore them to a better quality of life, or that will allow them to return to the workforce, then it will be deemed a reasonable and necessary and reasonable medical treatment. And the judge can award and order the insurer to pay for that medical treatment, unlike a contractual benefit that might come under a health and accident insurance policy.
So how do you apply then the analogy to to the marijuana here then? Because they found, according to your sister, that this was reasonable and necessary to his health. So why is this different?
Well, first of all, it's different for one major reason. We stipulated that if Mr. Wright feels that he receives a positive benefit by using medical marijuana, so be it. If he feels he's better because of it, we are all for it, but not on our dime and not at the risk of Central Mutual being prosecuted for paying for medical marijuana. If Mr. Wright wants to buy medical marijuana on his own dime and risk himself being prosecuted under the federal law, so be it. If he gets off opioids, we're happy about that. He's much better off being off of opioids, not being addicted to it. Central Mutual, as an insurance company, is happy that he's not being addicted to those kind of drugs.
Can I switch? Because we have limited time. I don't understand how you can impose this cost on the trust fund. Explain that to me. Why is that the case? Why would the trust fund have to pick this up?
Well, because Mr. Wright had a pre-existing impairment before his industrial injury, we were able to negotiate with the trust fund that his injury, but for his pre-existing condition, he would not have been his disability was substantially greater because of his pre-existing condition than it would have been had he not had that pre-existing condition. As such, we filed what we call a second injury fund claim against the trust fund, and we reached an agreement with them to reimburse us up to 75% of any future benefits that...
Okay, neither side has briefed this issue, and
I have briefed it. I have briefed it. It's the last part of my argument. I've included the approved Section 37 agreement in my brief, in the appendix. It is. So we have, because, bear with me, Mr. Nason. Having done some of this before, pre-existing stuff is very complicated. You have a real discussion in your brief. I read your brief, but I've forgotten that. Yes, it's in there. I believe it's the very last very last part of my brief. Very last argument.
Okay. And has the other side addressed that as well in this? Because I'm wondering whether a 16L submission on the pre-existing issue, again, if it's fully briefed by both sides, I don't see any need to it. But given how complicated pre-existing analysis is in workers' comp, I hope it's not a couple of sentences in your brief. That's all.
Well, it was a done deal, if I may put it that way. In that we have an approved agreement. I attached it. When we settled the case, the trust fund paid us $96,000 as part of the settlement.
And the trust fund, just refresh my recollection, the trust fund is paid for by all employers by a surcharge. How does it work? How does the trust fund work?
Yeah, there are contributions made to the trust fund by all employers every year.
So essentially 75% of this would be picked up by all the employers in the Commonwealth?
Essentially, that's a simple way of putting it. I had the agreement in front of me. It's only one of my hands works at the moment. I'm sorry to say. I have the agreement here. It was dated, and it's in the brief. It was dated February 15th, 2017. It was signed by a colleague in my office, Attorney Richard Schwartz. It was signed by.
I get that there's an agreement. I just want to make sure we understand the legal consequences of the agreement in the context of paying for marijuana treatment. But essentially, what you're saying is that if we impose this, 75% of the cost will be imposed on the trust fund, which is a collective responsibility of all the employers in the Commonwealth.
Yes, in effect, yes. I mean, the exact language of the agreement says that the trust fund will reimburse Central Mutual 80% or 75% of all future related medical expenses. And if you deem Mr. Wright to be entitled to, the court, be entitled to future medical or past medical expenses, i.e. the medical marijuana, then we will turn around and request 75% of the cost of that medical marijuana from the trust fund pursuant to the Section 37 agreement. The trust fund, I'm sure, will resist that.
Is the trust fund a governmental entity? Again, I should know this, but I don't remember. Is it a governmental entity, the trust fund? Is it a public entity?
They are part of the Department of Industrial Accidents. They cover uninsured employer benefits that pay cost of living adjustments, etc.
Okay, that's all I have. Thank you.
They're part of the St. Pierre case that was heard at the appeals court, which was stayed pending this case.
Okay.
All right. But before I start, I do, following up on Justice Kafker's questions, I do invite both sides to, in a 16L letter, to address the consequences, if any, of the fund. So I invite both sides, if they wish, to write a short 16L addressing whether there is any relevance of the fund to the decision in this case. Mr. Nason, let me just make sure I understand your position. The position, you agree that this particular individual is better served by having taken medical marijuana than by taking the alternative, which would almost certainly be narcotics. Is that correct?
If he says he feels better and he functions better, I'm not going to argue with that.
Okay.
I can't say that I really agree with it, having learned much more about it. And quite honestly, I'm a child of the 60s, as, in fact, Judge Gans and I are exactly the same age, and we grew up very close to each other in New York. And having learned now, looking at the menus involved with both medical and recreational marijuana, THC is really the ingredient that the Controlled Substances Act was aimed at making illegal. THC is what makes people high. And when you're high, I mean, you feel great. And I'm not a scientist and I can't speak to this, but, going back to my wild years, if I may say so, the THC, I mean, I felt great. I mean, I was either mellow or I felt no pain at all, or I was happy. Maybe the same thing's happening to Mr. Wright.
Okay, well, let me without getting into more details to the glory of your youth in the '60s. Do you agree that his use of medical marijuana here was an adequate, was a reasonable and necessary health care expense under Section 30?
I agree that he might have felt better.
Okay. Well, that's not my question. My question, I mean, there is
I'm not a doctor. I can't say.
Insurer has an obligation, as you well know, to pay the reasonable and necessary cost of services, and services, I believe, include adequate and reasonable health care services. So, but for your argument that it is preempted, do you agree that there would be an obligation to pay?
Again, all I can agree to is that if he says he feels better and it got him off of opioids, then I agree that that's a good outcome.
Okay, well, let me rephrase the question. If Congress changed the law to say that medical marijuana is to be treated, say, as opioids, which may be viewed to have medical benefit and can be prescribed, would you agree that there would be an obligation to pay?
Then it's a whole new ballgame, Your Honor.
Okay.
And I would reluctantly say yes.
Okay. So then the question is whether it would be a crime for the workers' comp insurer to pay if it were mandated. Correct?
If it were not a controlled one substance and it were not deemed a federal crime, and my client was not exposed to the risk of federal prosecution, then we would have to pay for it.
Okay. Now, what is the crime which you say they would be exposed to? What crime could you say arguably they would have committed?
Under the present law, they would be aiding and abetting by paying for, by reimbursing, by allowing him to procure an illegal substance, medical marijuana, a Class 1 substance under the Controlled Substances Act, which is still a crime under federal law.
Okay, and I'll ask you the same question I asked your sister. Are you aware of any case, federal or state, in which anyone has been prosecuted either as a co-conspirator or a joint venturer or an aider and abettor for reimbursing a person for the medical expense involved in medical marijuana?
No, I'm not, Your Honor.
I have no further questions. Any questions of my fellow justice?
Yeah, I have one follow-up.
Justice
So the
Kennedy.
Chief asked you if it was reasonable and necessary, and it wasn't a crime and preempted, but you left out a step, right? You still believe that you're a health insurer, and therefore you're not required to pay by the statute itself, right, and the regulations. Is that correct?
That's correct. I believe we are a health insurer.
So separate and apart from preemption, you believe you have no obligation to pay because of 7B, correct?
That's correct.
Okay.
We are required to pay health benefits, medical benefits, and wage replacement benefits to injured workers.
Yeah, but my question is, at least I thought you were arguing, although you wait until the very end of your brief, I thought you were arguing that 7B says you are not required to pay marijuana expenses. Therefore, even forget about whether you have any exposure to aiding or abetting. liability, you still don't have to pay because you're a health insurer and they carved you out. They carved out medical marijuana payments in the statute itself, right? Or am I misinterpreting?
Yes. However, let me ask, if I may, we would not be, if somebody ordered us to pay for cocaine, I don't think we'd pay for that either, because that's illegal. In the same way that medical marijuana is illegal under federal law.
Right, but I'm cutting out the illegality for a second. I'm just saying that forget about whether it's illegal or not. The statute 7B, the regulation, said you do not have to pay for medical marijuana. That, whether it's legal or illegal, doesn't the statute carve out that from your obligations if you're a health insurer?
Yes.
Okay, I have no further questions.
I've got another question. Mr. Nason, that statute that was referring to, Section 7, says nothing in this law, meaning the medical marijuana law, requires any health care professional nothing in this law requires any health insurance provider, any government agency or authority to reimburse any person for the expenses of the medical use of marijuana. Is it your suggestion that where it says nothing in this law would mean that even if you were required under a different law, Chapter 152, Section 30, that it would protect you from paying under Section 30 because Section 7 says nothing in this law shall require you to?
No, because we can't ignore the federal law. We'd have a possible conflict again.
Okay, so you're going back to the federal law. You're not resting your argument on Section 7.
No, that's what creates the positive conflict between the state and the federal law.
Okay. All right. I have no further questions. Any further questions of the fellow justices?
I'm completely confused now by the last answer. May I inquire, Chief?
Yes, Justice Lowy, you may.
Okay. So, for instance, the regulation 935 CMR 501 nothing requires any health insurer, provider, or government agency or authority to reimburse any person for the expenses of medical use of marijuana. And Section 7B says that a health insurance or government agency is not required to reimburse any person for the expenses of medical marijuana nor authorize the use of it. Is your position that if but for federal preemption, you would not be able to rely on that statute and regulation to not reimburse?
You're saying but for the federal law?
Could you just rely on Section 7B and the regulation not to reimburse?
I believe so.
All right. Fine. Thank you. I have nothing else.
Okay, that concludes the argument, and we will commence ensemble in about 2 minutes. Thank you.
Thank you.
Thank you, Your Honor.